I'm asking the attorneys to turn their videos on and to unmute. Letting the law clerks in, starting the recording, and letting I know we can start. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-1289 et al. TransCanada Power Marketing Ltd. Petitioner versus Federal Energy Regulatory Commission. Mr. Sunbat for the petitioner, Mr. Kennedy for the respondent.
Good morning, counsel. Mr. Sunback, when you're ready, please proceed.
Good morning. Thank you. May it please the court, Mark Sunback, counsel for petitioner TransCanada. We'd like to start with a couple themes that relate back to the last time this case was before this court. In that decision in 2015, the court noted, quote, FERC made no effort to define the relevant markets or determine the participants' market power. We're back, and one of the reasons we're back is that FERC still has not made any meaningful effort to define the markets or test participants' market power within those defined markets. Having failed to define a market adequately, FERC can't make a determination regarding the existence or exercise of market power in any meaningful or judicially sustainable fashion. First, the geographic scope of the market has not been identified or even addressed by the Commission on remand. There was no showing or analysis concerning what the appropriate geographic market would be. The system operator, for various purposes, breaks itself down into many different units. For instance, their dispatch zones, their reliability zones, their load zones. There can be as many as 19 different fractured pieces of the system operator, but the Commission never addresses what the proper size of the geographic market is. Nonetheless, the record clearly shows that geography was an important limiting characteristic for terms of the products. You'll see, for instance, in both the testimony that accompanied the initial filing and the bid materials.
Something about this issue, which is the question of market definition, the way that it was presented in the rehearing papers and also in your opening brief was pretty bound up in your argument that the Commission erred by not applying the market-based rate regime correctly. And I just understood that the Commission doesn't even address the market definition argument in its response brief, and we can ask the Commission why. But I had understood your argument about market definition, including the geographic scope of the market, to be bound up in your argument that the Commission erred in its application of the market-based rate regime, as opposed to a freestanding argument that there's a problem with market definition.
Your Honor, we don't intend for that to be the interpretation at all. There are a variety of standard guidelines for determining, as you know, whether there's market power, and different agencies have different yardsticks, different tests and ways of dealing with determining market power. And we're not saying that in this instance, clearly there was a, let's call it prefabricated template that was available for use that the Commission decided for whatever reason it was not going to use. We contend that it was error not to use that prefabricated method, but regardless of whether they did use it or not, there is, in addition, the substantive error of, if you're not going to use the existing rules, then you have to come up with some way of determining what the relevant market is, and they haven't. They've presumed that the geographic market is apparently, although they haven't even explicitly said this, the entirety of the system operator's footprint, even though the system operator repeatedly has determined that it's, especially in periods of high stress, which is what this program is intended to address. There's not free-flowing communication of electrons from northern Maine to southwestern Connecticut. There are many bottlenecks, and we've seen that in many cases before this court and in the materials that were actually submitted by the system operator, which recognized the importance of, for instance, the north-south and east-west zones, if you will, and where assets were located within those. It would be amazing that, having been sensitive to the locational needs in order to achieve the goals of enhanced reliability, if the commission then said, it's all one big market, one big happy market, we don't care. Obviously, the system operator cared very much. And so when we get to, for instance, the quantification of the size of the market, and when the commission says, oh, well, we're not going to test the market at 1.95 million megawatts, we'll test it at 2.25 million megawatts, the commission's just expanding the market and thereby diminishing any result of market power that might be determined regardless of geographic limitations or the important product market limitations.
But the commission gave a pretty extensive explanation as to why market power was not a serious issue in this case. I mean, you really are wanting them to go to form, and what they are saying is this was a special circumstance. We used the bidding, the auction process to address a special one-time circumstance, and they're entitled to do that if they justify it. You really want them to go to particularized form. They didn't, and they acknowledged they didn't. You can't characterize it by reference to pre-existing forms. They used the auction approach here, and they explained why market power was not an issue. I don't know what more they're supposed to do. What's your quibble with their explanation? It's pretty extensive. What's your quibble with their explanation as to why market power is not an issue?
Your Honor, there is an extensive volume of verbiage, but just like the decision involving the Environmental Defense Fund v. FERC that was issued by this court in June of this year, a lengthy order is not to be confused with rigorous analysis.
No, that's you're avoiding my question. I'm asking what's wrong with the explanation. They have given an explanation, long or short, they've given it. They have explained, they looked at two different approaches on the cost, and they explained why they were adopting the approach they did, and they explained why market power is not an issue. And they explained that no, they're not using what would appear to be routine to you because this was a special circumstance. There's nothing in the law that prohibits that.
Your Honor, first of all, they did not claim this was an experimental program. Second,
not experiment. You're putting words in my mouth.
Okay, I apologize.
They didn't say experimental. They said they devised this approach, this auction approach, to address this situation. It's just like your argument on retroactive rate making. It doesn't make any sense in light of what they're doing. It's just not a viable argument. It misses the point. They had a single problem here they were trying to address. But I still would like to know what the particular mistakes are in your view with respect to their answer to there's no market power issue here.
Your Honor, the Market Monitor's report details the absence of specific information that was requested. FERC could have and has the authority to request the information necessary to compute costs. And the claim is in their justifications, oh, well, we already determined costs. We did a proxy determination of costs, and that allows us to draw the intercept between demand and supply and match that to the actual bids. Well, if you're using made up, quote, cost, unquote, data, then sure, you can probably get there. But if you add a 25% adder without any quantification, any justification for the quantification, if you put your thumb on the scale for all the other costs, including presuming when there's a bid, it should be justified as either the higher of cost based, which there are no actual costs for many of the elements, as you can see in, for instance, pages A4 and A5 of the IMM's report filed on January 23rd, then there's no substantial evidence behind this. This is all conjecture. The commission could have, without any materially greater effort, obtained the cost data from the 18 participants rather than allowing half of them to basically say, no, we're not even going to give it to you. If this was really cost justified, you would think that the merchants would have every incentive to provide that information to the market monitor and say, look, we invested quite a bit in making sure that this service was available. They didn't. The market monitor got stiff-armed, as you'll see in its report, on a lot of the data. And so the market monitor tried to come up with some kind of proxy. But in light of the fact that the service was represented to be a cost-based service from the outset in 2013, according to the testimony of the ISO and its own filings, it's passing strange that the commission and the market monitor and the system operator did not require the production of accurate cost information.
Let me ask my colleagues if they have additional questions for you, Mr. Sunback.
Nothing
I
more.
don't.
No.
I don't.
Thank you, Mr. Sunback. We'll give you a little bit of time for rebuttal.
Thank you very much.
We'll hear from the commission now. Mr. Kennedy.
Morning, Your Honors. Robert Kennedy on behalf of the Commission. Petitioner's argument had two basic tentpoles. One, the Commission erred in defining the market, that it should have been broken down further. And two, that the Commission erred in failing to, press the bidders for actual cost information above and beyond what they supplied to the market monitor. Neither of those issues were raised in TransCanada's request for rehearing, and they've been waived. The request for rehearing is at page 211 of the joint appendix. It was concise and precise. It alleged that the commission erred that the Federal Power Act precluded the commission from using a market paradigm to evaluate the results of this auction. And it said the commission had failed to point to substantial evidence that supported the use of a 25% ban to judge competitive bids. And within that was sort of a sub-argument that the commission, that the market monitor erred in failing to look at the cost of capital, the weighted cost of capital information and verify it that was provided by the bidders. With respect to that last minor point, that is one input in a multi-input formula that that the market monitor used to evaluate one of the risk elements in his bid construction, and the commission explained why that was wrong in paragraph 27 of the rehearing order. Sort of getting back to where petitioner started, why we're here, this court's remand, and it asked the commission to better explain why it believed the rates resulting from this program were just and reasonable.
Can I just add, before you just go there, on market definition, in the rehearing petition of JA 221, the rehearing petition does say, second, the commission failed to make an ex ante finding of the absence of market power, or even describe what it believed to be the dimensions and parameters of the relevant markets when approving the program under a market paradigm.
Well, I think, again, as you pointed out, that was part and parcel of their argument that the commission's market-based rate program, all the elements of the commission's market-based rate program had to be followed here in order for the commission to use market principles to judge the reasonableness of the resulting bids.
Is that how you understood it and understood the commission to understand it? Is that was part and parcel of this argument about the application of market-based?
It is how I took it, and it's clearly how the commission took it, because as Judge Edwards observed, I mean, these are pretty comprehensive orders, and the commission made a determined effort to respond to the remand with respect to, why the commission came out the way it did, why it thought these rates were just and reasonable. The commission went into more detail on the benefit side, that this is an undisputed risk to the New England region for blackouts if the system isn't if there isn't oil backup available to the natural gas generators in New England, it could cost ratepayers up to billions of dollars in lost revenue in the region if the blackouts were to occur. Now, obviously, the commission didn't say, well, we got $1 billion on the benefit side, anything goes. It took a hard look at the resulting costs of the program, which were $75 million. It compared them to a competitive benchmark. It looked at whether there were aspects of the design of the program that could reasonably be assumed to curb the exercise of market power. And then again, it looked at the expert analysis provided by the internal market monitor. With respect to the first, comparing it to a competitive benchmark, the commission said, okay, what would have happened if we used a uniform clearing price auction where under bidding theory, participants are encouraged or incentivized to bid as close as possible to their costs to ensure that they clear. Everyone gets the same price, gets the price of the marginal unit. And when the commission did that, it found that had that market construct been used for the winter reliability program, the cost would have been $88 million, 13 million more than what resulted here. So that was one data point that the commission looked at in assuring itself that these rates were just and reasonable. Then it looked sort of at theory. It accepted the market monitor's view that there's structural market power issues here. And the commission defined the relevant question as whether is there evidence that it had been exercised. And it first looked at the design of the program and found there were a few elements that would tend to curb any exercise of market power. One is that there was a lot of uncertainty on the demand side. The program rules said the market monitor was looking to obtain up to 2.4 million megawatt hours per month. And it could come in less than that, as it did. And as it showed in the program rules and in the first auction, the system operator showed itself to be a price-sensitive buyer. The costs the first time around were too much versus what they got. So they went back for more. The commission found that would tend to incent people to bid a bit closer to their cost, so to ensure that their bid is actually selected. The commission also noted that under the program rules, the system operator wasn't just selected.
Can I ask you one question about that point, which there's on the 25% adder, because it bears on the 25% adder, there's two points that are being made in the commission's order and in the briefing that seem at least somewhat in tension on the surface in my mind, but you tell me what's wrong with this. So for example, on page 45 of your brief, you explain why the commission was right in finding it unlikely that the participants knew they had market power. And in other words, that the market's functioning competitively. And the first point made is that the winter reliability program was an entirely new product market, which has the capacity to make it function more competitively in terms of the bidding, I take it. And
yes.
And then on page 58, in explaining the 25% adder, which sort of goes in the opposite direction because the adder boosts the price. The point is made that the winter reliability program was a novel market with many unknowns. And so it seems like the same point that the winter reliability program was a new product market, both keeps the prices in the competitive range, but also justifies a 25% adder.
Well, I think obviously the commission is talking about two different things, but to answer your question, yes, I mean, the commission thought that market participants, because this was a brand new market, wouldn't be aware that they had market power. And so as a result, they would tend not to exercise it. What the commission is doing with the 25% adder, I mean, the question is the commission has to, and the market monitor as well, set a price and create a presumption above what price should we deem a bid to reflect some exercise of market power. And sort of the options were the marginal cost-based bid identified by the market monitor or something else. And all parties, the market monitor, the system operator, and the commission agreed that some accommodation needed to be made for these additional factors. The fact that parties, yes, it's a brand new market, so they would be unlikely to exercise market power, but they also don't really know how to value these bids because it's never happened before. So we don't want to penalize and characterize conduct that is innocent and is competitive simply because it doesn't match up. It falls within a band of the market monitor's, price. So that's kind of why the commission used the analysis in both places. That it is new, so people will be unlikely to know that they had market power, know how to wield it. But they're also preparing these bids for the first time, and there may be, we need to account for that and allow some bandwidth above the market monitor's view of the competitive cost-based bid before we create our presumption of an exercise of market power, which again, as we noted in our brief, is kind of consistent with the way the system operator does it in its tariff with its other established markets. The internal market monitor will create a reference bid, and when it's reviewing an actual bid, there's a bandwidth. If it's sometimes $25 or 50% over the bid, if it falls within that range, it will not be deemed inappropriate. And that's kind of the same process that the internal market monitor went through here and the commission adopted.
So am I right? I'm not saying this is necessarily wrong, but am I right in understanding that the commission thought that the novelty of the market both had the effect of keeping bids within a competitive range, which is, i.e. suppressing them, but also had the effect of raising the bids to build in some kind of risk premium, and that's why you can justify the adder.
Well, I think if I could put it this way, yes, it has the effect of limiting the exercise of market power because it's new, but also there's uncertainty around what a competitive bid is. So because of the novelty, so we need to account for that in some manner in the analysis, and that's sort of why the issue comes up two places.
The assumption being they haven't bid enough and we want to make sure they're getting what is reasonable. That's the adder?
No, the assumption is that they, is a bid. I mean, they're getting what they bid. The adder doesn't give them any costs or anything like that. But right. It's there as a mark for the commission to say anything above this, we're going to presume to be the result of market power. And anything below, we're going to deem it to be competitive. Okay. So it's for that purpose. I see my time's expired. If there's other questions.
No. I don't think we have any further questions for you, Mr. Kennedy. Thank you.
Thank you, Your Honors.
Mr. Sundback, we'll give you 2 minutes for your rebuttal.
Thank you, Your Honor. Several points. First, the reference by counsel to the two tests applied by FERC. The uniform clearing price analysis, the first one he referenced, is premised on the cost study of sorts. So if the costs presumed in the study were erroneous, then the uniform clearing price analysis can't be presumed to be valid. The second test that the commission used, according to him, was based on the inflated 2.25 million megawatt hour market, which once again disregards any limits on geography or product markets. The reference to price uncertainty and price sensitivity that the ISO had, first of all, the Winter Reliability Program was disproportionately approved by generators 7-1 and opposed by end users in the Markets Committee by 7-1. So there was a price sensitivity, but the sensitivity on the part of the generators was to a higher price, and that's why it was approved. So yes, there was price sensitivity. There was also urgency, as you'll recall in the August 26th filing. No, I'm sorry. August 9th filing, the ISO tells the FERC, we haven't got enough. We need to hurry up. This is really little short of a crisis. So that undercut the notion that there was price sensitivity depressing the price. Council referenced the standard the commission used, which was, we presume anything over this is clearly the exercise of market power. Well, regardless of whether that's appropriate, that subsumes a potential for the exercise of market power. Below that, it's just not as obvious. We disagree with the characterization offered by counsel that the commission made that second step, which was to say, oh, and it's obvious that prices below this threshold don't represent the exercise of market power. In fact, the ISO, as well as the Market Monitor, in the January 2017 filing, acknowledged that the overcharges could be as much as $6.6 million. Finally, I'm sorry.
So if you have one final point, you can make it quickly.
The 25% adder, in addition to being unjustified to start with, was taken whole cloth by the FERC and applied to a much higher reference price. Recall the Market Monitor applied it to a $15 price, which yielded a $3 nominal increase. The FERC gave no consideration to whether that was still an appropriate nominal increase as opposed to this conceptual percentage increase. Thank you for your attention and questions, Your Honors.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Judge Srinivasan, can you hear me?
Yes.
Okay, good. Okay.
Case number 20-7113, Hulley Enterprises Ltd. et al., appellants versus Russian Federation. Mr. Shepard for the appellants, Ms. Lamb for the appellee.
Good morning, Your Honors.
Shepard, please proceed when you're ready.
Thank you. Good morning, Your Honors, and may it please the court, Stephen Shepard for petitioners' appellants. I respectfully request 2 minutes for rebuttal. Your Honors, 3 factors distinguish this case from the typical confirmation proceeding under the New York Convention. And together, these 3 make the stay order in this case clearly wrong. First,
can I just ask you at the outset? I'm sorry, I apologize for interrupting you right at the beginning as you're getting started, but I'm just curious where we are in this case now, because we have a communication from the Justice Supreme Court saying that it's going to issue its decision on November 5th, which is just a few days from now. And the district court stay order expires of its own force when there's a resolution in the Dutch Supreme Court. So is there every reason to suppose that this entire matter just this part of the matter goes away on November 5th?
Your Honor, there is a possibility that the Dutch Supreme Court, if it rules as we hope and expect it will, would render moot the petition for mandamus that we have filed directed at the stay. Of course, Your Honor, we don't know how the Dutch Supreme Court is going to rule, and the communications we've sent to the court don't indicate one way or the other what the ruling will be.
But in terms of whichever direction it rules, that still ends the stay proceeding. I mean, the mandamus proceeding. I guess if there's a reference to the ECJ or something like that, then it's possible that proceeding continues. But apart from that, won't it end the mandamus proceeding?
Your Honor, if the Dutch Supreme Court were to do as the Dutch Advocate General has advised and dismiss the cassation appeal, that would lift the stay under the district court's order. If the Dutch Supreme Court were to do as the Russian Federation has urged and refer the matter to the Court of Justice of the European Union, it is at least debatable as to whether that would lift the stay. The stay order in this case refers to resolution of proceedings in the Dutch Supreme Court. And the way the mechanism works is the Dutch Supreme Court proceedings go on after such a referral. There's years of briefing in the Court of Justice for the European Union, and then the case is sent back to the Dutch Supreme Court for more proceedings.
If there's a reference, so I guess where you're at is, yes, it could end it. If there's a reference to the European Court of Justice, then you think there would be the argument that the mandamus proceeding continues because there hasn't been a resolution, and so the district court wouldn't end its stay. But then in that situation, would the reference itself support the proposition that there's no clear and indisputable right to relief, because that would suggest that the Dutch Supreme Court thinks that there's some pretty significant issues?
I would agree that the Russian Federation could be expected to make that argument, Your Honor. We still believe that the mandamus would be appropriate for the reasons that we'd like to address.
Okay.
The first factor that distinguishes this case, Your Honor, is the excessive length of time that's been going on. 18 years ago, the Russian Federation destroyed Yukos and expropriated my client's investments. 16 years ago, the arbitration proceedings began. And 7 years ago, the awards were handed down and these confirmation proceedings began. And yet, after all this time, we still don't have a ruling from the district court in this case as to the threshold issue of the Russian Federation's sovereign immunity. We are still effectively near square one in the district court. The second factor, Your Honor, is that there is little practical hope that my clients will ever be able to collect prejudgment interest from the Russian Federation during this very long stay. In the Stillex case, this court recognized that prejudgment interest was a dictate of national justice that deters any attempt to benefit from inevitable litigation delay, and which is especially relevant in the arbitration context. Here, Your Honor, $7 billion of prejudgment interest, post-award interest, had already accrued at the time of the stay. We expect, and we told the district court, an additional $7 billion would accrue during the stay that the district court was contemplating and has ordered. We have little practical hope of collecting that. We'd have to first collect on the $57 billion already owed, which may well exceed the non-immune assets of the Russian Federation in this jurisdiction. This is in the face of a debtor who has made plain by its actions as that it has no intention of paying the money that's owed and has been ordered by the awards. And in the face of what the district court called troubling aspects of the Russian Federation's lack of compliance with orders from courts both here and abroad that should weigh heavily in favor of what the district called a bond, what we call security, in order to protect my clients. And the third factor, Your Honor, is the Dutch Court of Appeals opinion. It's extraordinary. It's a 130-page document based on 3 days of oral testimony, thousands of pages of briefing, and it comprehensively refutes every relevant defense raised by the Russian Federation. The cases that the Russian Federation primarily relies on were state cases in which there had been no decision from the primary jurisdiction. Here, the first decision from the Hague District Court decided just one defense that the Russian Federation had raised. That was the issue of whether the Russian Federation had agreed to arbitration in the Energy Charter Treaty. That turned on Article 45, which deals with the provisional application of the treaty after it had been signed. That one issue, Your Honor, has been comprehensively refuted by the Court of Appeals, which did it in two ways, both as an interpretation of the Energy Charter Treaty, but also the Court of Appeals assumed the Russian Federation was right about how to read the Energy Charter Treaty. And it then went on to make findings of Russian law, finding that provisional application of the arbitration provision would not be inconsistent with Russian law. That's section 4.7 of the Court of Appeals opinion. And it's in the record, Your Honor, at beginning at page 1496. That opinion, that finding of Russian law, is not subject to direct review in the Dutch Supreme Court in the cassation appeal. The standard of review, which is not in dispute, and it is discussed by Mr. Jehorum's declaration, the Dutch counsel of my clients. Particularly, I invite the court to review his declaration at page 1681, where he discusses how the Dutch Supreme Court cannot review the legal correctness of this finding. And at 1673, where he describes the standard of review that will apply. In the face of these three factors, Your Honor, the district court's reasons for the second stay were clearly wrong. There were essentially three when you boil them down between the discussions of the two standards. First, the district court said briefing may be easier after everything is done in the Dutch court. Second, a litigation quagmire, and third, international comedy. Those reasons, in short, Your Honor, would apply in every single confirmation proceeding, and if allowed to support the stay here, they would return this jurisdiction to the pre-New York Convention regime, the Geneva Convention, in which you always had to exhaust all appeals in the primary jurisdiction before confirmation. I see I only have—
the problem, I'm trying to cut this case back. There are two questions that are before us: mandamus then you have an extraordinary burden on mandamus in any case coming to this court in order to be able to get relief. And I don't know how you can get relief when the New York Convention allows a secondary jurisdiction court to issue a stay if the district court judge feels it's appropriate because the matter is being considered in the court with primary jurisdiction. You clearly have that here. It's not, honestly, not compelling to me that the Court of Appeals opinion is extraordinarily favorable to you. That begs the point. It begs the point that the matter that the district court is waiting for is not yet done because it's at the Dutch Supreme Court. So what that the Court of Appeals decision is impressive for your purposes. And I'm thinking in terms of mandamus. So that's a really compelling consideration against you. The court has the authority to issue a stay under the New York Convention. It's absolutely clear that they have this authority if you're waiting for another decision. And that's all they did. And so in terms of mandamus, I don't know how you get over that. In terms of on the other question, I think what the court said was, its finding, is it wrong? That they rested on the conclusion that the Russian Federation has significant US assets that could be seized to satisfy any judgment. That's a district court finding justifying the second point that you're contesting. Unless I find that that's completely wrong, I don't know how I get to your second point. I don't understand what you're meaning to say about failure to make a decision on sovereign immunity. You're throwing that in as, I'm telling you my impression. It comes in as kind of a, gee, that's unfair. You know, maybe it is, but I'm not sure how to weave that into the legal analysis when the court clearly has the right to issue a stay pending disposition in a foreign court. So I'm not sure, are you meaning to say that that somehow changes if they fail to issue a decision on sovereign immunity? And you mentioned it again today in passing, but I'm not sure where you're putting it. They have the right, the district court has the legal authority to issue a stay under the New York Convention. And you're asking for mandamus. And I'm, as a judge, mandamus is, we almost never give mandamus because it's such a hard standard to meet. And it seems to me impossible here when the court is acting pursuant to legal authority, which says I can wait if I think it's appropriate. And I think it's appropriate to wait.
On the mandamus point, Your Honor, we refer to the Belize social case, which noted that mandamus is appropriate in New York Convention cases, given the emphatic federal policy in favor of arbitral dispute resolution. Turning to the second point, security.
No, but that doesn't answer it. The New York Convention I'm looking at as a judge on a panel that has this case where the district court judge, where you're trying to mandamus, it says, there's another decision pending. And the New York Convention says I can issue a stay and wait to see what the other court says. How can I give mandamus in that situation? And tell you candidly, my view is I can't. I know there are other considerations about speed, but we're so far past speed, right? And I say that respectfully. We're long past that. We'll all be retired before this thing ends, the way it's going. But I don't know how you get mandamus. And then on the second point, the court is saying, I'm making a finding that there's enough money here to satisfy a judgment in the event that it comes to that.
So on the second point, Your Honor, respectfully, the court made no finding and received no evidence. And in fact, the district court's opinion mentioned incorrectly, referred to global assets abroad. I think we could all assume that the Russian Federation, if you include the assets within that jurisdiction, within Russia, exceed $57 billion. But the district court's authority in this confirmation proceeding, as Your Honor rightly points out, refers to assets in the United States. There's no evidence of assets anywhere close to 57.
So you're saying it's not a finding that can be credited by us. It's simply language and an opinion that has no basis, is your view?
Yes, Your Honor, it's not a factual finding. The district court received no evidence. And moreover, the primary reasons for denying security were the erroneous legal presumption against awarding security and the district court's failure to decide its sovereign immunity, the sovereign immunity question. Article 6 of the New York Convention, which Your Honor is looking
So
at.
that's where you want the sovereign immunity to be in play.
Yes, the district court denied us security because it said, I've stayed my decision on sovereign immunity.
Can I ask you on sovereign immunity, on waiting to decide sovereign immunity? Usually there could be a problem with waiting to deny sovereign immunity because the sovereign wants its immunity resolved. This is kind of an odd situation because this sovereign actually doesn't want its immunity resolved. It's in favor of the stay. And so it's a little bit, I mean, this case is either side could accuse the other side of being rich because you both have made a lot of arguments at this stage that are exactly contrary to the arguments you both made previously, because the interest in a stay has switched. One of you wanted to stay before and the other one wanted to deny it. And now the one who wanted to deny it previously wants it, and the one who previously wanted it wants to deny it. But in terms of sovereign immunity, where we are now, whatever Russia said initially when it has in its initial position, it doesn't want sovereign immunity decided right now, as I understand it, because it wants to stay. So I don't know about the force of requiring a court to resolve foreign sovereign immunity when the foreign sovereign doesn't want its immunity resolved.
Well, Your Honor, to address that point, foreign sovereigns who are facing a confirmation proceeding rarely would like the sovereign immunity or anything else resolved. The debtor always seeks a stay and always points to the set-aside proceeding. In this particular case, Your Honor, Article 6 of the New York Convention, which Judge Edwards was referencing, not only gives the district court power to enter a stay, but also says that it may order the respondent to give suitable security.
You know, you're absolutely right, and there's no question that that's there.
And what we're asking for in our second point, and by the way, this is a collateral order appeal of the denial of security, which everybody agrees, so the mandamus standard does not apply. Right. What we're asking for is a fair hearing.
And I'm not confused on that. I understand that point. They're different standards of review.
And there's legal errors that should be reversed and at the very least vacated. It's an error to deny us a fair hearing on security based on a sovereign immunity issue that the district court refuses to decide. Right. If that's going to be the basis, and it's particularly important here that the district court indicated in these 2 pages of its opinion that there are troubling points about this case and the Russian Federation's lack of compliance with orders that weigh heavily, those are the district court's words, in favor of granting a security. But it decided that we couldn't have a hearing on that. We wouldn't get a chance to exercise our right to ask for this under Article 6 of the New York Convention because the district court didn't want to decide the issue, and instead it stayed it. That combined with an incorrect legal presumption against ordering sovereigns to pay security, never adopted by this court, are the 2 legal errors that are directly before this court and we think can and should be reviewed. I see my time is up. If there are no further questions. Thank you, Your Honors.
Thank you, Ms. Shepard. We'll give you a little bit of time for rebuttal.
Thank you, Your Honor.
Ms. Lamb, we'll hear from you now.
Yes, good morning, Your Honor. Carolyn Lamb with White & Case on behalf of the Russian Federation. We have a completely different view, as you might imagine. First of all, we are not in a New York Convention proceeding. We're way before that. That's merits. The court has not decided jurisdiction under the FSIA, and the court has not decided the New York Convention issues at all. The stay that she issued was a Landis stay, a stay under the Landis decision of the Supreme Court that is preliminary to the jurisdictional determinations and the merits determinations. And the question is, how did we get here? Why has it taken so long that Mr. Shepard complains about? We got here at the outset because they asked for it. After the decision of the arbitral tribunal, they sought a petition here to enforce that decision, and in France, and in the UK, and in 6 other countries.
What's wrong with that?
Pardon me?
What's wrong with that?
I'm just explaining it. I'm going to tell you what's wrong with what he's saying now.
No, but I want to understand. You're suggesting that seeking enforcement of an arbitration order in multiple jurisdictions is somehow problematic. I just thought that's the way these things happen. Is there something actually wrong with that?
Well, it's wrong with it if, in fact, we have immediately a request to set aside the award of the tribunal. And at the same time, the Russian Federation wanted its immunity determined. We immediately filed motions to dismiss the petition, two on the basis of the foreign.
Do you want your immunity decided now?
Yes, but not at this moment, of course.
Well,
and for good reason. For good reason, and we still have immunity, to be sure, because the Dutch Supreme Court is deciding the Energy Charter Treaty where issue Article 45.1, whether the Russian Federation was solely a signator and therefore only agreed provisionally to apply the treaty consistent with its laws, and its laws do not permit arbitration in tax cases, in public cases, etc. It never ratified the treaty. It never was a contracting state that offered arbitration. It didn't offer arbitration or any of the benefits of the treaty to Russian investors, which they were operating through tax haven shells. And it never agreed to offer arbitration to have the context here where we've got money laundering, tax fraud, fraud and corruption on their part. One of the claimants before you, petitioners before you, in fact, we've traced, and it's in the motions pending in front of this court, a $600 million payment in the initial privatization to get their shares. Now, I like to think this court is not going to ignore all of that. And all of those issues, and then some, are pending in front of the Dutch court on the set aside. He makes light of the Dutch court proceeding, saying, oh, we're going to win, just like the Advocate General said. Well, we already won once on the Article 45 ground. We've already won once in the UK court, where they continue to stay, saying the probability of success on the merits.
Can I ask you something?
Yes.
Is your motion to the district court on sovereign immunity still pending?
Yes, that's what he moved to stay in.
No. And I'm just trying to get it straight in my head. So your motion for sovereign immunity is, I don't understand what would be the problem for this court to, with this court sending it back to the district court in answer to that question and say, decide the question of sovereign immunity and then decide the question of security, depending on your answer.
Well, in fact, Your Honor, in the Term Rio case and in the Gitma v. Guinea case, you know that the primary jurisdictions decided, in fact, to annul the awards. If that is the result in the Dutch court, why should I'm being really parochial. I just want to be a little-minded judge here and take the little case that we have before us on appeal. We got two questions: mandamus, and we got the absence of security, which you both are tying to an absence of decision on sovereign immunity. Is the answer to the second issue for us to send it back to the district court and say, you cannot continue to hold up the request for security until you've decided that sovereign immunity question? You've got the motion before you decide it. Your Honor, no.
Why is that wrong?
That's wrong because at this point, all of the same issues would have to be decided by the district court.
No, they wouldn't. The district court has its own proceeding before it. And it is saying, with respect to the request for a stay, I'm waiting to see what the Dutch court is doing.
Exactly.
I've got another motion before me. The district court says for sovereign immunity. It is a motion that has to be decided. The court's not doubting that. And the answer we're getting with respect to the request for security as well is no answer on sovereign immunity. Why isn't the appropriate answer for this court to tell the district court decide it and then decide the question on security?
Because it is entirely appropriate, given the many factors that the court considered.
With respect to what? With respect to refusal to decide the question on sovereign immunity? In other words, I honestly don't understand. And when I first prepared the case, and I still don't understand it, why doesn't the district court go ahead and decide the question on sovereign immunity?
Because she will be deciding the very issues, albeit under US law, that are pending in front of the Dutch court, and to go through all of the remaining briefing and all of the remaining effort by the parties, when in a few weeks it could be thrown out entirely, is not what a landis stay.
All right, why wouldn't our order say in a few weeks when we know what the Dutch, unless everything is gone, by virtue of the decision from the Dutch court, decide the question of sovereign immunity?
Well, Your Honor, it may all be gone. It may not all be gone. And
I'm just asking, I'm trying to be as practical as I can. Why don't we just have it decided? No more fooling around on that, because that's tying up the question of security.
Well, actually, Your Honor, it's more complicated than that.
Oh, I understand it might involve some complicated questions, but I'm still trying to
No.
understand why is that inappropriate?
It's inappropriate because the Dutch court, of course, is part of the EU, and the interpretation and application of the Energy Charter Treaty, as you can see from the Comstroy decision, is something that the ECJ will decide and opine on.
So at the outset, when you initially filed your motion
Right.
on sovereign immunity, I assumed that you wanted a decision that way. You didn't say that we're filing a motion for sovereign immunity, but hold on to it because there's a bunch of stuff going on in the Netherlands that are bound up in this. So we just want you to take it and hold it. I thought at the outset you actually wanted it decided at a time.
We did, because we had confidence in the US courts that they would apply the rule of law, and they would in fact decide that there was an absence of any offer of an agreement to arbitrate here, that there was fraud and corruption at the outset, that they were less than candid with the arbitral tribunal in withholding documents and providing false statements, so that this is not an award that we ever think will be enforced. Why? The court does have to reach a very high threshold in terms of determining whether the district court exceeded her authority. This is exactly the kind of decision that Sinochem contemplates, a preliminary landis stay. They asked for the landis stay. We both
And you opposed it.
We did oppose it.
Right.
But then after the Dutch court decided in our favor,
Is there further review after the Dutch Supreme Court? I don't know all the intricacies of how that system operates.
Not by a Dutch court,
By the Dutch court.
but there could be by the ECJ if certain issues were referred, or there could be other international proceeding. So in any event, it is in fact not finished, I'm sure. And we also have a variety of issues under the New York Convention. But this isn't a New York Convention stay. This is under Article 6 at all. This is a landis stay under the landis Supreme Court decision. And she had complete discretion to do what she did on the record that was before her.
Let me make sure my colleagues don't have additional questions for you, Ms. Lamb.
No.
Oh,
Thank you, Ms. Lamb. We'll give you 2 minutes for rebuttal, Mr. Shepherd.
Thank you, Your Honor.
Can I start by just asking one clarification question, which is for the security issue? The request for posting of security was for security pending the resolution of the stay, right?
It's pending confirmation, Your Honor. When security is ordered, it's paid into the registry of the court, so it's there that once the awards are confirmed, the money can be paid to the creditor.
So if the stay evaporates, because let's just suppose on November 5th, the Dutch Supreme Court issues a decision that the district court concludes as a resolution such that the stay goes away, what happens to the security part of the case?
It's a complicated question, Your Honor, that we need to think about.
Okay.
The stay becomes moot if the case goes away in the Dutch Supreme Court. Security, I don't think would become moot. So 3 points, Your Honor, in response to Ms. Lamb's presentation. One, our response brief on the FSIA issues is in the district court record. It's docket 63. We explain why there is no sovereign immunity under section 1604 from this suit. All that's needed to be done is to update that with the Stillex decision, which makes even more clear that there's no sovereign immunity here. The only possible issue would be whether there is an agreement to arbitrate. That is the Article 45 question Ms. Lamb refers to, and that is the one I referred to in my opening that has been decided already by the Dutch court as a matter of Russian law, which is not subject to review. Finally, Your Honor, it is simply wrong to say that there's a Landis stay different from a New York Convention stay. That's contrary to the Belize social case, where there was a foreign sovereign immunity defense not ruled on by the district court. This court considered that a New York Convention issue, the granting of a stay. There was no distinction between the two. The same was true in Stillex, Your Honor, where this court acknowledged the inherent authority doctrine, citing Clinton v. Jones, a Landis case, but also said the district court would abuse its discretion if it were not to consider the 2 Europcar factors. There aren't 2 frameworks, Your Honor. There's 1 framework, and this has always been a New York Convention case with a pro-enforcement bias. I see my time has expired.
I'm perplexed by your answer to the Chief Judge, that you're confused about the security issue. If the Dutch, depending upon what happens with the stay, if the Dutch court goes the wrong way as far as you're concerned, and security has been posted, what's the confusion?
There would be no confusion there, Your Honor. In that case, we would have gotten what we're entitled to under the security provision of Article 6.
And the security would go back. I mean, it would not remain available to you.
No, it would be with the district court, Your Honor. Security would never be paid to us. It would be paid to the district court.
But it's to protect any judgment. Isn't the security to protect any judgment that you might get in the district court?
Yes, Your Honor.
Okay, if you can't get a judgment,
that's shown in the Warren Treaty.
Yet, if you can't get a judgment because of what happens with the Dutch court, then the security is dissolved. Whatever the appropriate piece of paper is that's signed, it's no longer available.
Yes,
right?
Yes, Your Honor.
Well, I'm not sure what you're confused about then.
I'm sorry. My confusion was whether the appeal of the denial of security would become moot. Maybe I misunderstood the Chief Judge's question. That's the complication. Okay. But to Your Honor's point, absolutely. If we lose this confirmation proceeding, the security goes back to the Russian Federation. If we win, it comes to us. In the meantime, it stays with the district.
Okay. Thank you.
Thank you, Your Honor.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 20-1791, Pao Tatneft versus Ukraine, care of Mr. Pavlo Petrenko, Minister of Justice, appellant. Ms. Kostitska for the appellant, Mr. McDonald for the appellee.
Good Morning, Counsel. Ms. Kostitska, please proceed when you're ready.
Good morning, Your Honors. May it please the court, in the interest of time, I will address two grounds for appeal: illegality and forum nonconvenience, and answer any questions you may have regarding the two other grounds: arbitrator bias and excess of subject matter jurisdiction. Illegality. The award that Tatneft seeks to enforce is based on illegality. Enforcement should be denied under Article 5 of the New York Convention. First, due to the limited scope of Ukraine's offer to arbitrate disputes relating to legal investments under Article 5.1c. And second, due to the American public policy against illegality under Article 5.2b. If the court were to allow enforcement, it would lend its aid and reward illegality. The vast majority of Tatneft's claims is for the loss of its indirect shareholding in Tatneft, a Ukrainian company. The indirect shareholding was acquired using promissory notes, essentially promises to pay. Ukrainian law prohibited capitalizing a company with promissory notes. The public policy reasons behind the prohibition were similar to those of the DC Code, such as promissory notes often proved to be uncollectible. If promissory notes were counted part of the stated capital, shareholders and creditors would be misled or defrauded. And paying for shares with promissory notes dilutes the equity of the other shareholders. It also causes the company to forego other sources of capital. In this case, Amherst and C Group, foreign incorporated shell companies with concealed beneficial ownership, squeezed their way into Tatneft to form a voting alliance with Tatneft. And these shell companies paid for their shares with promises to pay $65.8 million, and only $3 million were ever collected. After the illegality of the share purchase.
The implications of this argument, would it mean that anytime an award is thought to be in violation of foreign law, that it implicates the public policy exception?
Your Honor, the illegality argument in this case implicates two provisions of the New York Convention. The first one has to do with the scope of the offer to arbitrate, because the BAT between Russia and Ukraine specifically provides that disputes that can be arbitrated on the BAT have to arise out of legal investments. So the legality requirement is encompassed in the BAT, which is part of the agreement to arbitrate and which defined the scope of the offer to arbitrate. And as far as the public policy exception is concerned under Article 5.2b, not any illegality would implicate the public policy exception, but any illegality that is not trivial and that raises the type of concerns that I have just described will certainly come within the purview of the public policy exception, Your Honor. In the district court proceeding, it was uncontested that disputes relating to illegal investments are outside the scope of Ukraine's offer to arbitrate in the meaning of Article 5.1c of the New York Convention. And it was also undisputed that the United States has a public policy against illegality in the meaning of Article 5.2b of the New York Convention. Tatneft did not even attempt to defend the legality of the share purchase using promissory notes in these proceedings, yet the district court did not evaluate Ukraine's concern with the illegality of the share purchase using promissory notes and did not draw Article 5 consequences from it. The district court's order should be reversed and enforcement should be denied for illegality under Article 5. Turning now to forum nonconvenience. This case has no connection to the United States other than being a contracting party to the New York Convention. The locus of the dispute is in Ukraine. The witnesses, experts, and assets are in Ukraine. The dispute involves complex issues of Ukrainian law and also Russian and Soviet law. Illegality of the share purchase is central to this dispute. Tatneft has not identified any assets of Ukraine.
We have some decisions that seem to stand for the proposition that forum nonconvenience is not a basis on which there's relief in the context of a proceeding to enforce an arbitral award.
Your Honor, let us look at the last footnote of the forum nonconvenience section of TMR.
Right.
This is decision to which you refer.
Yeah, TMR and others that echo it.
And the last footnote of the TMR decision expressly carves out the question as to whether the forum nonconvenience arguments are available or unavailable in New York Convention confirmations proceedings from its determination. And I read, accordingly, we do not consider TMR's alternative contention that, contrary to the Second Circuit's decision in Monogas v. Naftogaz of Ukraine, the doctrine has no place in an action to enforce an arbitral award. So this particular question was specifically carved out from this court's determination. And the holding of Monogas of the Second Circuit was undisturbed. And in that particular case, the Second Circuit specifically held that foreign inconvenience is available as an argument in New York Convention proceedings. And why? Because Article 5 of the New York Convention sets forth the substantive defenses to confirmation.
So on the subject of footnotes, I thought that there was a footnote in our Stellix decision that says, I think relying on TMR, that says that forum nonconvenience is unavailable in the arbitral context.
Your Honor, that footnote refers and relies to TMR, and we submit that that footnote is dictum, because by the time the court got to that footnote, it already affirmed the confirmation of the award on two other grounds. The first one was the subject matter jurisdiction under the Foreign Sovereign Immunities Act, and the second one had to do with the pendency of some foreign proceedings. So after having affirmed the confirmation on those two grounds in the body, it got to this footnote. So we submit this as dictum. And so the only determination that perhaps would warrant clarification is
your audio is
breaking up. Yeah.
When you turn away, your audio is a little bit off. Sorry.
Your Honor, and I also would like to draw attention to Article 3 of the New York Convention, and this is the provision specifically that the Second Circuit interpreted. So while holding that the defenses in Article 5 are substantive matters, the forum nonconvenience argument is procedural in nature, and Article 3 of the New York Convention specifically provides that enforcement has to be conducted and done in accordance with the procedures of the forum. So according to Article 3 of the New York Convention, the forum nonconvenience argument remains available in New York Convention confirmation proceedings. So, Your Honor, this case has no connection to the United States other than the United States being a contracting party to the New York Convention. So why are we here today? Because of forum shopping. We submit that the reason why this Russian company with close ties to the Republic of Tatarstan, a unit of the Russian Federation, dropped a jurisdictional hook in this district is to seek worldwide discovery into the assets of not only Ukraine, but also numerous Ukrainian entities of strategic importance to the nation's welfare. This Russian company is seeking to mobilize far-reaching jurisdictional powers of American courts at times of geopolitical hostilities. This case should be dismissed for forum nonconvenience, and I will discuss very, very briefly. First, the district court erred in misconstruing the court's precedent, TMR, to provide for a categorical rule that a foreign forum is always unavailable, inadequate in U.S. proceedings to enforce an arbitral award on the New York Convention. And second, such categorical reading of TMR would contravene Supreme Court precedent, particularly Piper and Sinachem. With regard to the first point, TMR does not stand for such a categorical rule. It cannot be that a foreign forum is always inadequate and always unavailable in an action to confirm an arbitral award, just because any such action can be characterized as an action to attach property in the United States. Even whereas here, the judgment creditor has not identified any property of Ukraine in the district and has openly admitted that it is unaware of any such property. And as we just discussed, such categorical reading of TMR would be contrary to the last footnote of the forum nonconvenience section of that decision. Turning now to the second point, such categorical reading of TMR would contravene Piper and Sinachem. The rule under Piper has always been and remains that an alternative forum can only be inadequate if the remedy that it provides is so clearly inadequate and unsatisfactory that it is no remedy at all. And the examples were that the defendant is not amenable to service of process, or foreign law does not permit litigation of the subject matter of the dispute. And this is a very low standard of adequacy, easily satisfied here. And second, I would like to turn to Sinachem, which was decided 2 years after TMR. It confirmed the continued vitality of the forum nonconvenience doctrine because Sinachem was also an attachment case. And even though the attachment remedy was sought in that case, that did not preclude dismissal on forum nonconvenience ground. Had attachment been so—
I think we have your Sinachem argument from the briefing, and I just want to make sure that my colleagues don't have additional questions for you before we give Mr. McDonald a chance to respond.
No.
Oh,
Okay, thank you, Ms. Kostitska. We'll give you a little time for rebuttal. Mr. McDonald, we'll hear from you now.
Thank you, Your Honor. May it please the court, I'm Mark McDonald for the FLE Tatneft. This case, there's a limited issue in front of the district court, which is whether to recognize in the United States the final award, which was rendered in France and upheld by the courts in France. And as this court and others have recognized, the award debtor, Ukraine, in a case like this one, bears a very heavy burden to overcome the emphatic federal policy in favor of international arbitration awards and upholding our treaty obligations under the convention. The district court was absolutely correct to reject all of Ukraine's objections to enforcement of this award, even though they've been somewhat of a moving target in the 4+ years of this case. And all 4 of the issues, including the 2 that counsel discussed just now, that are raised on this appeal are meritless, and the district court's final judgment affirming the award should be affirmed by this court. So I'll start with the illegality point, which was raised. This is the issue of the way in which Amruz and C Group, which were not the claimants in the arbitration, but the way that those companies purchased their shares in the underlying company in the 1990s. And those shares were then purchased subsequently by Tatneft, the claimant in the arbitration. Before the court can even get to the merits of that issue, Ukraine actually waived this argument, and not just once, but twice. The first time was in the arbitration itself, where Ukraine specifically requested that the arbitral tribunal address its own jurisdiction, and it raised 4 separate jurisdictional arguments, including a very similar argument that Tatneft's own purchase of the shares in the company were outside of the bilateral investment treaty of the BIT. Very similar argument to the argument that's being raised now with respect to the Amruz and C Group shares, but it never raised the argument that it's making to this court today as an argument.
As far as that argument comes through the lens of the public policy issue, I'm not sure that it's waivable, because that's not seeking to vindicate the interests of a particular party. That's seeking to vindicate the interests of the United States.
I agree with that, Your Honor. So the structure of Article 5 of the New York Convention is that Article 5.1 are the defenses that have to be raised by the party resisting enforcement, and then Article 5.2, including the public policy exception, are sort of available to the recognizing court, if you will. And the public policy argument comes under that the latter of those 2. But
you're only talking about 501c. Is that your
that's where I was starting? But I'm happy to talk about Article 5 too.
No, I didn't realize this the same underlying factual.
It is.
The gravamen surfaces both under 501c and under public policy, and I just didn't know which branch you were talking about.
Yeah, that's a fair point, Your Honor. So just let's finish on 5.1c. The waiver was clear in the tribunal, in the arbitration itself. It again waived the argument in the district court because in July of 2017, when Tatneft had filed a petition in the district court, the district court ordered Ukraine to respond to that petition with its New York Convention defenses, and it did so, raising the arbitrator bias point, which is raised again on this appeal but wasn't discussed just now, and a separate argument as to this allegation that Tatneft had acquired the Amruz and C Group shares from Amruz and C Group to manufacture jurisdiction in the arbitration. That issue is separate from the illegality of Amruz and C Group's own purchase of the shares, but anyway, that issue has been abandoned on this appeal. It's not been raised. Even if the issue had not been waived under Article 5.1c, it would not succeed under this court's precedents, including Chevron and more recently the Silex decision that's been discussed today. Here, just as in both of those cases, the bilateral investment treaty incorporated by reference the 1976 UNCITRAL arbitration rules, which this court has found constitutes clear and unmistakable evidence that the parties delegated arbitrability questions to the arbitrators. Now, Ukraine made an argument in their brief that, well, that doesn't matter because the arbitrators here didn't make a finding on the illegality points, and so there's nothing to defer to. But with respect, that's because Ukraine, again, did not make this argument in the arbitration and never raised this issue as a jurisdictional defense in the arbitration. And I would point the court to language in the Silex decision from earlier this year that when the parties delegate arbitrability issues to the arbitrators, it's not merely a question of deference. It's just that the court has actually no power to decide the arbitrability issues. That was a question, if it was going to be a question, for the arbitrators alone. So turning, Your Honor, to 5.2b, the public policy aspect of this argument. As this court has said time and again, public policy is a very narrow exception to a New York Convention case seeking recognition of an arbitral award. And it simply does not encompass, however Ukraine wants to phrase it, illegality under Ukrainian corporate law. Obviously there's no public policy of the United States with respect to that. But okay, let's say, does the United States have a public policy with respect to the purchase of shares with promissory notes? Well, maybe there was some sort of policy in the District of Columbia in the 1980s when the DC Code prohibited that type of purchase. Whatever that policy reason was has since been abandoned because the code has since been revised and now you can purchase shares in a company with promissory notes. But regardless, that's not the type of public policy that's so well defined and dominant that it can overcome the recognition of a foreign arbitration award that's subject to the New York Convention. The only types of cases where that exception has been successfully invoked involve fraud or other very unique circumstances, and nothing like that has been alleged here. And I would also note that the public policy exception is not an occasion for the district court or this court to substitute its fact finding for the arbitration tribunal's fact finding. That was the holding of the Supreme Court of the United States in the United Paper Workers case. Unless any of your honors has any questions on the illegality point, I'll turn to forum nonconvenience, although
what's your response on the 5.1d tribunal composition?
Sure, Your Honor.
What standard do you think the district court applied?
Well,
district court apply evident partiality, justifiable doubts, or something else?
I think if you look at the district court's opinion, that
I did
actually used all three standards that have been suggested in this case and found that.
Do you think the district court said under justifiable doubts, I'm reaching the same conclusion?
I think
if you can point me to language, that's what I was trying to figure out, because it really is very unclear what standard the district court is applying. Now, if it's true that the district court said, I'm reaching the same result with respect to all three, then of course I'd look at it that way, but I couldn't get myself there.
I think you're right, Your Honor, that the justifiable doubt standard comes from the UNCITRAL rule.
Right.
And I think the district court, her decision was that cannot be the standard.
Do you agree with that?
I agree with it in the following sense. So in this court, in the Belize Bank case, found, well, it said, right, that in an arbitrator bias case, as opposed to a case presenting a question as to how the arbitrators were selected, like, maybe there would be an issue under 5.1D
But
if
the Belize dealt with the public policy defense.
I agree, but what the court said was, in a case like this where the allegation is that the arbitrators were biased, the only potential grounds under Article 5 was not 5.1D, but 5.2B, the public policy exception. And the reason that is because this is not a question about how the tribunal was composed. There were rules,
So then the district court, I think you're trying to dance away from it. I'd really like an answer. The district court spent a number of paragraphs, as I remember, on this question and was talking about these different standards. I thought the correct answer would be the justifiable doubts is the correct standard. And I'm wondering if you think the district court applied that standard. And your first dodge was to say, well, she applied everything. I'm not sure that's right. And if she didn't apply justifiable doubts, can we reach that decision on our own, or do we have to remand for determination on that?
I think, Your Honor, there's no dispute of what the facts are. This court can decide it on its own if it thinks that that's the right standard. If I can just explain for a minute why I don't think that's the right standard. The combination of this court's decision in Belize Bank and this court's decision in the Republic of Argentina versus AWG, I think explain this. So in AWG, that case was a domestic arbitration case under Chapter 1 of the FAA. So the evident partiality standard applied. Now, interestingly, that case also involved an arbitration governed by the UNCITRAL rules. But in that case, this court said, even in a Chapter 1 case, it's not the justifiable doubt standard under the UNCITRAL rules that applies. It's the evident partiality standard under the FAA. Because you don't just get to come into court after you lose an arbitration and say any sort of foot fault under the underlying arbitration rules. It gives me an excuse to undo.
I don't see how evident partiality can apply in a case with respect to an international issue.
I agree, and it certainly does not. And that was the point in the Belize Bank case, which is to say that in a Chapter 2 case like this one, the evident partiality standard does not apply. And in fact, the standard is even tougher. Because this is not a primary jurisdiction case where the court has more latitude to undo an arbitration award. It in fact has less. And so if Ukraine's argument were accepted here, it would be backwards, right? You would be in a Chapter 2 international arbitration award case, you would actually have more latitude to undo an arbitration for an allegation like this than you would in a Chapter 1 case, and that just can't be right.
Okay.
All right, let me make sure my colleagues don't have additional questions for you, Mr. McDonald.
No.
Thank you.
Thank you.
Mr. McDonald. Ms. Kostitska, we'll give you 2 minutes for your rebuttal, please.
Thank you, Your Honor. With regard to the waiver point, Ukraine did not waive its illegality argument by not raising it in the arbitration because it did, in fact, argue the illegality point during both the admissibility and jurisdictional phases of the arbitration. So even though the illegality argument was raised, it was not squarely addressed in the award on jurisdictional admissibility. And then most certainly Ukraine raised illegality of the share purchase as a merits defense. And the tribunal did not address this issue and merely stated that a contrary view that a share purchase with promissory notes being legal was tenable. So stating that something is tenable is not a determination. So this question was never resolved by the tribunal, even though this question was put before it. And we also do not accept that we waived the illegality argument before the district court, because in the argument section of the opposition, not just in the factual background section, in the argument section, we stated in Ukraine's submission, enforcement of the merits award would lend the court's power to wrongdoers, Amers and C Group, which unlawfully acquired their shares and Pao Tatneft using promissory notes in violation of Ukrainian law. So this point was argued before the district court, and the district court could have and should have drawn Article 5 consequences from this argument, most certainly under the public policy exception. But if more clarity was necessary to brief this argument under the scope exception, Then we requested supplemental briefing when additional Ukrainian law evidence became available in the UK proceeding. So had a full argumentation been helpful, we offered to provide it, and well, on this particular ground. And opposing counsel raised the point with regard to, Your Honor, I see that my time has expired. May I finish this one point?
Yeah, you can finish this one point quickly. Thank you.
Yes, so the last point is that we are not foreclosed by Chevron to raise this point, because Chevron does not allow to re-argue admissibility arbitrability determinations that were actually decided by the tribunal. And there is no authority that precludes you from looking into points that have not actually been decided by the tribunal. And there was no factual finding by the tribunal this particular point, and there is nothing to defer to you.
Okay. Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Thank you, Your Honor.
Thank you, Your Honor.
This honorable court is now adjourned until Monday, October 18th at 9:30 a.m.